Very much, Madam Chairperson, and dear colleagues. It's now time for us to all weigh in on Bill C-45, and I'd like to thank you for your diligent work on this file. We have proven once again that the Senate can function well, hold high-level debates and exercise its role as the chamber of sober second thought, and to remain an institution that is core to the protection of our minorities.
Yep. We must address this fundamental change in a mature, serious, and responsible manner. Our job is to make sure that the legislation we pass makes Canada a better place. The
Senate will have adopted 44 amendments to Bill C-45, of which 29 were moved by the sponsor himself, Senator Dean, for a bill that has been touted on several occasions as being perfect, and this is therefore a remarkable fact. I hope that the government will demonstrate the necessary openness such that all of these amendments will be kept in the other place, and we have certainly improved Bill C-45. Despite these improvements, C-45 remains, in my opinion, a botched, poorly constructed legislation for Canadians, and its coming into force will not have been prepared with the necessary care. We'll be legalizing a human product for consumption without the necessary scientific evidence, which will have uncertain effects on its users. I'd remind you of the objectives that the government set for itself under the Cannabis Legalization Act, and I quote,
"From accessing cannabis to protect public health and public safety by establishing strict product safety and product quality requirements, and to deter criminal activity by imposing serious criminal penalties for those operating outside the legal framework," end of quote. Given the testimony of experts and representatives from numerous organizations and associations we heard in the past few weeks, I must conclude that this objective will not be met with the bill before us. Et je ne suis pas le seul à penser comme...
And I'm not the only one to think this, as was demonstrated by our work in various committees. Senators heard from over 200 witnesses representing a vast array of sectors and studied the bill from numerous perspectives. This is gargantuan. I'd like now to turn back to the facts that have been presented and the shortcomings with which this bill is still unfortunately saddled. To begin with, international treaties. As you're fully aware, Canada is a signatory to 3 UN drug control conventions. These conventions are in effect contractual agreements and form the basis of international law that signatories must comply with, and it's a matter of the rule of law. So it is highly worrisome to hear from a federal senior official, Mr. Mark Goodwetsky, Assistant Deputy Minister, International Security and Political Affairs, Global Affairs, Canada, candidly admit before the Foreign Affairs Committee a possible violation of these treaties and play down this non-compliance. And I quote, "We are going to violate a subset of provisions on cannabis under these conventions," end of quote. The Minister of Foreign Affairs also acknowledged that, yes, Canada was going to infringe upon these treaties, and legalizing cannabis will put Canada in a situation where we violate our international commitments. This is an untenable situation. How can we ask other countries to adhere to conventions and international treaties when we ourselves are so reckless in this respect? Saying that legalizing cannabis is a domestic response to a domestic problem, as Mr. Freeland testified before the Committee on Foreign Affairs, is not a valid excuse to skirt our international obligations. It's instead the kind of response that we'd expect from rogue regimes when they are taken to task by the international community. The government knowingly failed to meet its international obligations under C-45. Aboriginal Indigenous peoples. Testimony before the Committee on Indigenous Affairs spoke volumes about the impact of the legalisation of cannabis. Indigenous communities are already coming to grips with substance abuse issues, and the legalising cannabis will only add to this overwhelming burden. There are multiple problems: a lack of public education, a lack of treatment and substance abuse and detox centres, and police resources. Steve Burden from the Tutina Nation Police Service stated the following, and I quote, "In my opinion, the funding agreements for First Nations communities, and most particularly those for the police services for the First Nations, are problematic. The ambitious timelines are perhaps well-intentioned, but unfortunately they're not realistic because we will not be able to enforce the legislation," end of quote. People from these communities and their representatives offered up touching testimony regarding their concerns. Chief April Adams Phillips from the Mohawks Nasaski Council had the following comments. This would help us to look after our youth if were we to have our own legislation. The Atasasi situation is unique. We are along the border of Quebec and Ontario, and we need legislation that is tailored to our land. I don't want members of our community to leave our land in order to obtain cannabis. We put behind us all the problems that came from tobacco use in the 90s, and we don't want to see that reoccur, end of quote. This lack of resources will be in addition to the economic problems. In fact, this whole boondoggle is a result of a lack of a consultative process with Indigenous nations. Yesterday, at the last minute, Senator Harder in fact, pulled a rabbit out of his hat with the government's commitment to hold a consultative process after the bill passes. And this is therefore a haphazard, botched effort. Why didn't the government decide to consult before legalisation? The constitutional obligation to consult Indigenous peoples came prior to this bill, not after. Any consultative process after the decision is a masquerade which seeks to cover up a denial of justice and the irreparable harm caused. Our relationship with the United States. The Foreign Affairs Committee looked to see whether legalising cannabis would have an impact on Canadians' eligibility for the Nexus or Express Pass program.
Impact of C-45 on these programs, but serious planning in the bill will have prevented this kind of situation. During our trip to Washington, we met with senior officials and representatives of the U.S. government who had not been briefed on the impact of C-45 on the free movement of people and goods at the border. Yet the government keeps attempting to minimize these impacts and refute the evidence. D'autre part, des témoignages.
Moreover, testimony from Canadian border agents regarding their preparedness for the coming to the force of the legislation is not reassuring. Vague testimony about future communications plans, informal meetings with the U.S. authorities, studies, vague assertions. That is how the federal officials' work is moving forward. Very little substance, no concrete plan. Here's what Kevin Thompson, who was the Director General for the North American Strategy at Global Affairs Canada, had to say. For the time being, what I can tell you is that we are working closely with the various actors of the US administration in order to highlight risk areas and eventualities as a result of this legislation. We have close dialogue that we are entertaining with our US counterparts, and these were one of the issues. This was one of the issues that was raised, and for the time being, the administration has not voiced its intention to address these issues at the border. End of quote. Unfortunately, this Mr. Thompson's quote is typical of the vacuous response that the committee received. Minister Goodale's testimony stated it would be business as usual when crossing at US checkpoints. He admitted, nevertheless, that awareness and education efforts are required. Quite clearly, the government hasn't undertaken serious negotiations with our neighbours in the south to avoid these kinds of problems. So we are left with making predictions about what the US Customs and Border Protection Agency officers' actions will be. The ramifications could be disastrous. And this is going to slow things down at the border. Some people will be subject to expedited removals. These are some of the results of legalizing cannabis. Now, if we've learned something over the recent months, it is that the Americans are far from agreeing to our position. If we don't have a legitimate dialogue with the US administration, we risk placing our tourists and Canadians in problematic situations.
The issues with Bill C-45, there is the legal age of cannabis consumption. There is a lot of confusion in C-45 on the government attitude towards consumption by youth Canadians. On one hand, the main objective of C-45 is to make sure that the access of youth to cannabis is restricted. On the other hand, C-45 is designed to make sure that youth consumers are not criminalized. Under C-45, it will be legal under federal law for a youth person of less than 18 years to possess 5 grams or less of cannabis. But if a young person of less than 18 are prohibited from having access to legal cannabis, where will they get it? The answer seems clear. They will buy cannabis on the illegal market. So how will the strict requirement on production protect them? À cette confusion sur les objectifs.
In addition to this confusion regarding the objectives of legalization is the fact that setting a minimum age for cannabis use at 19 is based on no science whatsoever. Quite to the contrary. Here is what the Psychiatric Association of Physicians stated. Scientific research has established that the human brain continues to develop until the age of 25. We acknowledge that teenagers don't have the intellectual capacity of adults, particularly when it comes to managing impulses, organizational capacity, anticipating cause and effect, decision-making, moral judgment, end of quotation. Dr. Milton Can, who's the medical director of the Substance Abuse Centre at the Wollmein College Hospital, Family Medicine, University of Toronto, added to this comment, and I quote, I firmly believe, just like many of my peers, that the legal age limit should be 25, not 17. At age 25, the brain has reached maturity, and at that stage, cannabis causes less damage. Increasing the age limit will make it harder for our youth to use cannabis. If we set the age limit at 25, it will send a strong, powerful public health message to our youth that the use of cannabis is dangerous and should be avoided. End of quotation. C-45, therefore, will not address cannabis use by our youth. Clearly, the 18-year age limit is devoid of any scientific foundation and was a random choice by the government. I lament that the amendments do not, in fact, are not in line with the scientists' consensus on these issues. Home cultivation. Home cultivation is the root cause of a number of problems that don't seem to be have been on the government's radar screen. The government has no plans to protect our youth when it comes to homegrown cannabis. The Barreau of Quebec has noted that the state of Colorado put in place security measures to limit access to cannabis. The state, which is used as an example or role model for legalization, in fact decided to offer up a number of plans. And the government decided to pass off this problem to the provinces and territories. The Barreau's decision was clear, and I quote, "To ensure the safety of our youth and all Canadians, we believe that home cultivation should only be permitted in an enclosed, protected space akin to what occurs in Colorado and in California," end of quotation. Now, these substances should be in an enclosed, locked compartment and not left open in an open space with unfettered access for our youth. How did the government come up with the 4-plant limit? Law enforcement has decided that it will be impossible to enforce this legislation. The President of the Canadian Chief of Police said the following: "When it comes to home cultivation, the Association of Chiefs of Police of Canada have continued to argue strongly against this measure for the time being. We believe that home cultivation is an offence that will be impossible to enforce, that will create additional opportunities for illicit, unlawful possession and overproduction of cannabis. Moreover, we believe that home cultivation will pose additional risks for our youth because it will expose them to the hazards of cannabis use." Mr. Tom Stamakatis, who's the president of the Canadian Police Association, had very worrisome concerns that he raised, and I quote, "Some of the provisions under this legislation will be almost impossible to effectively enforce. Regardless of the additional financing that the government or funding the government might provide, enabling individuals to grow and possess up to 4 marijuana plants is a perfect example. I have trouble understanding how any police service in Canada would have the necessary resources, whether it comes to police officers or money, to enforce this legislation and monitor those provisions," end of quote. One of the goals of the legislation is to set the quality standards. How can you control the quality of homegrown marijuana? Asking the question is easy, answering it is hard. Does the government have any idea of how much cannabis can be produced annually by growing 4 plants? And does it know how high these plants will grow? The THC levels in cannabis produced by licensed producers will be stringently regulated. But what of home cultivation? And what about derivatives for personal use? Unusual amendments regarding home cultivation, or rather positive amendments, have been rejected. And unfortunately, there are huge gaps in the legislation on this issue. Now let's turn to organised crime. Combating the illicit market is in the final parts of the legislation's preamble. Ironically, the media has already published editorials, and we've noted that a number of illicit producers are enjoying spin-offs from tax havens for the production of cannabis. We're talking about millions of dollars, and we have no idea who is behind the corporate veil. It is an open secret that they will be able to reinvest the proceeds of their crime in illegitimate companies. Assistant Chief on the Committee of Drug Abuse at the Canadian Association of Chiefs of Police made the following worrisome remark, and I quote, "We know full well that there are over 300 organised crime groups involved in the distribution and production of cannabis. This is an industry of over $7 billion annually. It's a gargantuan problem. Organised crime will quite simply not forgo this market," end of quote. Radio-Canada CBC just released surprising facts concerning the legalization of recreational cannabis in Colorado in effect since 2014, and I quote, "According to the state, legalization has had the opposite perverse effect. Even if there are over 500 legal outlets for marijuana in Colorado, the black market has the wind behind its sails," end of quote. The state of Washington and Alaska have both legalized recreational cannabis in 2012 and 2014 respectively. You'd be as surprised as I am to learn that neither state can provide official data regarding the ramifications of legalization in terms of a black market. So Colorado saw an increase of its black market, and Washington and Alaska don't know what the upshot will be either.
I sincerely hope that the government is right about its predictions on that the cannabis market will migrate to the legal market. I have serious doubts about the fact that the state could offer a service as efficient and at an equivalent cost as what criminals are offering, but one can hope. Yet we have an obligation to ensure that the government establishes mechanisms that will not allow organized crime to infiltrate the legal distribution network. The police have asked for improvements of the permit issuing process for production. Chief Mario Harrell from the Canadian Association of Chiefs of Police also said this: "We are also asking the federal government to adopt rigorous requirements and robust regulation measures for security attestations in order to ensure that criminal activities are not able to obtain production permits, as we have observed in the medicinal cannabis sector." End of quote. If the elimination of organized crime in the cannabis market is truly the objective, a responsible government must set out control measures for producers and recognized suppliers. We have adopted an amendment to the bill on this subject. I hope that the government will accept it. Not implementing a process of this type would only confirm a lack of seriousness when they claim to want to address organized crime. Other effects on public health. The government has completely neglected the public health aspect in its approach on C-45. The Minister of Health testified before the Social Affairs Committee that the government's approach is based on scientific data. But she indicated just afterwards that we will have a surveillance system to study the consequences of the legalization. I had the impression that I was before the creation of the largest living laboratory in the world, and Canadians, mainly youth, are becoming the lab rats. If the legalization is truly based on scientific data, we would have had an answer to our many questions, which was not the case. We are in uncharted territory about the long-term health impacts of cannabis legalization. Therefore, the government should have demonstrated caution, which it has not done. Furthermore, Health Canada is still warning users of medicinal cannabis and posted the following on its website, and I quote, "Use of the product includes health risks, some of which could not be known or fully understood. Studies that support the efficiency and safety of cannabis for medical purposes are limited and do not meet the norm established by the Food and Drug Regulations for medications offered on the Canadian market, end of quote. The government has presented no serious studies on the impacts on public health, on the costs represented that represent the legalization of cannabis on the health system. For a government that says to base its decision on data, it seems to have had no data before legislating. Indication of the THC rate on products. Senator Seidman proposed that the THC rate should be clearly identified on all cannabis products that will be sold in shops. This amendment is so logical and supports healthy public health practices. I still don't know how it was voted down. We indicate the tar and nicotine rates on cigarettes and the alcohol rate on wine and beer, but we won't indicate THC on cannabis products. I was rereading the statement of some senators in the independent Senate group who decided to support the government and reject my colleague's amendment. Senator Gold said, Canadians will know what they are ingesting, the THC and CBD rates of the product that they are purchasing, their location of production, and their producer. Senator Harder responded to a question by Senator Pratt on February 27th and said, and I quote, the government intends to make regulatory provisions to normalize the THC concentration in cannabis products and force suppliers to clearly indicate the concentration on the label of their products. What was the recommendation by the government working group concerning the labeling of THC rates on each product sold? I quote, we also recommend labeling all products with clear indications about their THC strength and CBD strength, as well as appropriate health warnings, end of quote. Will the regulation really contain this requirement? We don't know. The government refuses to publicly unveil its intentions. We are being asked to legalize cannabis under the pretext that the government will be able to figure out the marketing and packaging, but without knowing the text of the regulation. Public education. This is another subject of concern for me. The lack of public education on the effects of cannabis. According to the government's plans, cannabis will be on sale this summer. Where are the awareness-raising campaigns that were promised? What is the government waiting for?
One of the issues with C-45 is the rush in which the government seems to be. All the committees that heard testimonies on Bill C-45 heard that stakeholders feel rushed and are asking for delay in the implementation. Let me quote Mr. Yvon Soucy from the Fédération de la Fédération Québécoise des Municipalités. However, many aspects of Bill C-45 need to be clarified. This is why the FQM, like Quebec, would like to see the implementation of the Act delayed by a few months. The legalization of cannabis is a complex matter, and several questions do not seem to have been answered. End of quotation. There is no doubt that Bill C-46 is closely linked to Bill C-45. Clearly, our police force must be ready to deal with possible drug-impaired driving offense. Testimonies before the Legal Affairs Committee lead me to believe that we are not in a good position. At a minimum, drug-detecting devices using saliva are not yet approved and available, and we need hundreds of drugs recognition experts. Chief Mario Morel, President of the Canadian Association of Chiefs of Police, told us, and I quote, "We clearly require many more officers trained in the in the standardized field sobriety testing and as drug recognition experts. Quite frankly, the capacity is currently not there to deliver the amount of training required in the short term. Il reste donc beaucoup à faire.
Much, therefore, remains to be done. A number of witnesses told us that they feel pressured to get ready and face this bill. They have the impression that everything has been poorly done, improvised, and that time is cruelly short.
That most of the American state your government is fond of holding as example plan a minimum delay between the adoption of legislation and the coming into force of public sales. To mention only one, the state of Colorado passed a constitutional amendment legalizing cannabis in November 2012, while sales become legal on January 1st, 2014. Ne prenant pas le temps requis pour faire bien les choses, nous
By not taking the necessary time to do things properly, we are on a crash course for a number of unfortunate situations. The government has not carried out the necessary consultations with the Aboriginal peoples, and we will be violating our international obligations, particularly with the United States. The results of the fight of organized crime against organized crime and the effects on public health are uncertain. The government is making banal the cannabis consumption, particularly among youth. A number of provisions of the Act go against the stated objectives, like home cultivation and the lack of rules on THC concentration. Our police forces don't have the necessary tools to face criminal infractions that stem from cannabis consumption. That is what we have heard. Those are the facts. Canadians expect their governments to adopt well-thought-out, well-prepared, and structured measures. Visibly, Bill C-45 does not meet these criteria. In a number of ways, this bill demonstrates a level of improvisation, approximation, and shocking inconsistency. The government says that it wants to legislate by basing itself on the facts and not on preconceived ideas. But in the case of cannabis legalization, the reality is the opposite. Despite the abundance of evidence that cannabis legalization has been rushed and that the bill is poorly drafted, the government is refusing to back down out of pure political calculation and pure ideology. Allow me to quote Senator Harder on February 13th. Bill C-45 is proposing to address the high rate of consumption among youth in Canada thanks to a new strict control approach for cannabis and public education. It seeks to resolve health and safety problems that exist in Canada currently and to deprive organized crime of this market. The testimony that we heard do not lead us to believe that C-45 responds to the claims of the government leader. I am still wondering, dear colleagues, and this question remains without an answer, why did the government not study Norway with the lowest youth rate of cannabis? Why did it not draw inspiration from the best countries in the world rather than the worst? I therefore invite you, dear colleagues, to vote against Bill C-45 and to send the government back to do its homework. It could lead appropriate consultations and strike a dialogue with the United States on this topic. It could proceed with necessary impact studies and raise the awareness of Canadians, particularly youth, about the dangers of cannabis. And it could ensure that all stakeholders are ready, all stakeholders, and draft a bill and regulations that are both clear and effective, that will achieve the public health objectives to reduce consumption among youth and eliminate the black market controlled by organized crime. Thank you.
Thank you, Your Honour. I'm pleased to have the opportunity to rise to speak on this bill. It's a really important moment in time, in Canada's time, whether you're for the bill or against the bill. It is a major shift in public policy, And we've had the opportunity together to spend a lot of time looking at this. There is a lot of good work that has been done. I think a much deeper understanding of the bill through the deliberations that we've had at committees and listening to witnesses, and the conversations that we've had with each other in this chamber to try and understand and to get to the best possible end place together. I think that we all understand the polarity of views around the legalization of cannabis, and those polarity of views are held out in the common public. And I find in my conversations back in my home community that they're without purely ideological roots. From left to right, there are people who are in favor and people who are opposed. I think that where we have a common view is wanting the legislation to be the best that it can be. That leads some to say we should delay and take more time. That leads others to say we've got to have the right kind of effective reviews in place to ensure that we learn as we go forward and as more evidence base becomes available to us through the research dollars that have been committed in the particular projects that have been outlined and specified for study. I think when I came to this bill, I came to it with a general positive view about legalization of marijuana. And that comes from a public health background, the work that I did in community for many years, and then my time serving as a Minister of Health. And I believe that the prohibition approach to cannabis and to the war on drugs in general, but to cannabis in particular, has been a terrible failed public policy instrument. It hasn't worked. And it has left us without the kind of adequate research to really underpin good, solid, and knowledgeable, fact-based, evidence-based opinions in this place as we look at it. I've heard people stand up and say all the evidence shows that there are dramatic health impacts on 18-year-olds, let's say. Others have stood, as I have, and said, in fact, the latest evidence, the metadata analysis that's been done of all of the studies shows that the links are not clear and that they are tenuous at best. There's evidence to back the opinion you want to put forward. And I think it's really important for us all to remember that there isn't any one person who has the right knowledge or evidence here, because it doesn't exist yet. There are differences of opinions, as there are on so many things when it comes to public policy. So when I did my second reading speech, I talked about the history of prohibition, and the history of prohibition of cannabis in particular. I didn't know a lot about it, and through that research, I was fascinated to learn the history, where it comes from in Canada, the debates in the States about legalization, the different commissions, the steps that have been taken in different jurisdictions in North America, and of course our own journey here in Canada. I'm not going to repeat that, but it was instructive to me because it showed how long we've been at this and how long we've been debating, is prohibition versus public health the right way to go? Which way should we go? So this government has determined that it wants to take a public health approach to the issue of consumption of cannabis, and a public education and a parent empowerment approach to the consumption of cannabis. I think on top of that, the regulation of the product itself, the fact that while Senator Carignan made reference to this, not in the legislation, but in the regulations, in fact, it will be compulsory for levels of different kind of cannabinoids to be listed on the packaging. We will have consumer information. We will have better information than exists now, and there will be better public education. I think for me, all of that, so it sounds really balanced. There's pros and cons. There's people who are for or against. They're polarized. There's research for and against. Where do we come down? I believe this is the right public policy approach, and I believe no matter how much more time we took, there will be real problems with implementation of this massive public policy change in our society. And I think we have to be vigilant to that. I think we have to be prepared and understand and know, and not from an accusatory place, but from a pragmatic understanding as practitioners of public policy, that you actually have to start to implement and learn as you go from some aspects of public policy and public administration. That doesn't mean that it's just a crap shot, that we're going to let people's health suffer as a result of it. It does mean, however, that there will be, as I said, those bumps along the road, and we should learn from them. In the community sector, there's a lot of writing that has been done about developmental evaluation. And it is about, as you are dealing with people in complex biospheres, where it's not just, in this case, marijuana that might have an impact on this person's life. It's why are they taking the marijuana or consuming the marijuana. It's what are the other aspects of their life. What are the genetic predispositions to addictions. There's a range of things that will mean it's a very different outcome for different people. And so we have to have programmatic responses, both from a public health, from a public education, from a prevention point of view, that learns as we go forward. So that developmental evaluation should be built into all of our approaches. And I think that the Senate committees have done that, and this Senate today, again in the amendment this morning, has done that in terms of ensuring that there are right kinds of reviews. So in the legislation, there's a 3-year review that the ministers have to file reports of the implementation. There is a 5-year review where both chambers of Parliament must do a review and file their reports. And in the observations, and this is primarily what I wanted to stress, in the observations, we asked the government to bring together and establish an expert panel to work side by side with them while the implementation is taking place over the next few years, and to report on, monitor and report on that implementation and what's going right and what's going wrong. When I began my research on this bill, I was most concerned about mental health impacts. And as I reviewed the studies, I've become less concerned about the immediate connection to cannabis, but I remain very concerned about the lack of supports and resources, sufficient, adequate supports and resources that we have for people suffering from mental ill health in our country. There's much that we have yet to do. And I saw this bill and the discussion as a potential opportunity to push that agenda forward. When I spoke with experts in the field, what I heard back is, we don't need another FedProv strategy on this. We don't need just the commitment of more dollars. We need the dollars that have been committed to be monitored and to be the agreements to be lived up to as to how that is going to be invested in our communities in terms of mental ill health programmings and supports. And as I talked to those experts and had that in my mind and then spoke with some other people, I heard from other people the requirement to monitor as we go forward. Collapse this. There's a lot of people to speak tonight. I don't need to go on at length. This is an observation that we have in passing the report, have appended to the bill that we will eventually send back to the House of Commons, and it is a recommendation for this monitoring group to be established. The work of that monitoring group with an expert focus, and not only, I'm not demeaning our public sensitivity focus that we bring to it in our political debates, but from experts as well, to provide us with information for the Minister's review and for the Parliament's review as we go forward. So, Madam Speaker, I am honored to be with this group of people, to have participated in this, because I think it is one of those historic moments, and it is quite incredible to be here and sharing in this. I hope that as we go forward, we will all acknowledge, even on both sides, even if you're in favor of this legislation, that there will in fact be problems, and that we will need to monitor as we go forward. We will need to course correct. That is the wise, pragmatic, and correct way for governments to go about implementation of major public policy changes. Thank you very much.
Senator Lankin, would you accept questions? Senator Andrzejczyk.
Lankin, I thank your focus on public policy. I think it's important. And you say that we need some expert groups to monitor the progress. I fully agree with that. But good public policy would have in place some programmatic implementation before it's in place. And then you look at it to see whether it needs to be varied, changed. You work along and you change. But you need to know what the starting point is. And my dilemma here is, don't you think that proper public policy, you would know what we're going to do now so we could monitor it. But we're being told it'll be in regulations. We're being told there will be an education program rolled out. So we have no baseline to work from. And normally, you would have that baseline to start with, because implementation is as important as the law itself. So would you agree that we're going off what normally would be public policy that you and I have worked in those areas on?
I agree with some of what you said, but not all of what you said. I think that having a base that you work from, I would love to see more, for example, research data and evidence base for us to have a baseline that the research can monitor against. But by the way, it was illegal and they couldn't get the substance and get approvals to do as much research as they would have liked to. So we don't have that base. And we could take another 10 years or so to do that kind of research base. On the area of program implementation that you talked about, I certainly am aware of governments having done a really good job of development of a program, usually a little more narrow scope than what we're dealing with here. And I've seen governments of all stripes do really bad jobs of it as well. So we're in a very unique place in the Senate, being able to have the second look at things, as you would say. It appears to me this government went through a process of political decision-making to determine that this would be part of their campaign. They, as opposed to issuing a government, white paper, green paper, that approach, they appointed a task force which did consultations and brought forward a report with clear recommendations. That was then circulated. We had that in advance of the legislation. We had time to understand where at least those who were recommending to them were suggesting that they head. And we've had a suggestion that there will be some openness to the regulations. I don't know, honestly, in this kind of legislation, whether or not they would have got it better if they'd taken another 2 months or 3 months. I actually don't know that. They might have gotten it better, and that might be prudent. I know that I thought it rang very hollow when last year they introduced the legislation, and my colleagues, some were already talking about it being rushed through to get it done by this summer. Like, the task force reports and then I have more material than I think I've ever had on any kind of bill to have been able to go through and absorb and understand, and I thank Senator Dean for that, and some other senators who circulated materials. I think that was helpful. So, in an ideal world, could we do it better? Yeah. In a real world, have we done something where there has been a lot of time and effort, a lot of views? I don't know if you heard many new things through the process. I know some of the scientific evidence, I've heard new things. Most of the other stuff I've heard for years. So we have to take a decision at some point in time. I'm comfortable with my decision to support this legislation. I'm hopeful that a number of our amendments will be accepted. And at the end of the day, maybe over time we can convince governments that there's a better process. I kind of like the old green paper, white paper process where people could dig in on things substantially for a year or two before it came through to legislation. But many governments have abandoned that approach. It seems to be passé. I think that's sad. Thank you.